Hello, I'm Robin Henry, the head of Collyer Bristow's Dispute Resolution Department, and I specialise specifically in financial disputes, which increasingly involve crypto assets. This is our first Collyer Bristow webinar. Some of you may know that we were due to host this session as a seminar in conjunction with We Are Fintech earlier in the year. However, due to the current crisis situation, we've been forced to go online, but we still hope to reschedule that seminar for later in the year when hopefully the situation has changed. As I mentioned, this is our first webinar, but due to the current restrictions, we're having to record this remotely. So I hope you'll forgive us if the quality isn't perfect. For those of you unfamiliar with Collyer Bristow, we are a leading central London law firm with a long track record of servicing SME clients in the financial services and fintech areas. Our crypto and blockchain team works with entrepreneurs, SMEs, investors, and venture capitalists, advising on a wide range of commercial legal services. Now today, the purpose of our discussion is to explore the recent regulatory and legal changes surrounding the use of crypto assets and smart contracts. Our panel today are Nigel Brahms, a partner in our financial services department, Simon DeProys, a senior associate in our banking and financial disputes team, and Imogen Jones, also an associate in our banking and financial disputes team. So I will be acting as chairman for the discussion, and I'd first like to speak to Nigel first.
Well, thank you very much, Robin. It's a pleasure to be here today. Well, it's been an interesting year, or an interesting few years in the world of crypto assets and regulation. If you'd asked me even about 18 months ago what guidance there was in the UK, I would have told you almost nothing. There were literally a couple of statements from the FCA saying that crypto assets should be treated the same as any other regulated instrument, and that you needed to look at the fundamental guidance in the FCA handbook and to work it out on your own from there. Fortunately, we've moved on a bit since then, and back in early last year, the FCA issued something called a consultation paper 19.3, 19 being the year and 3 being the third consultation paper of that year, in which they went out to a wide range of financial institutions, law firms, accountancy firms, and advisors generally in the space, and asked their views in terms of how they thought crypto assets ought to be regulated. And later on, once they'd had the results of that consultation back, the FCA issued something called PS 1922, which was a policy statement. And now a policy statement is not absolutely law, but it's a very clear indication of the FCA's view of how these assets should be regulated. Now, just to give you a high-level view, I've done a lot of work analysing and whether or not certain types of crypto asset ought to be regulated, and particularly this was around issuance of tokens, or coins as they might be known. The FCA have issued guidance, and they've broadly divided crypto assets into 3 categories. And these are what are known as exchange tokens, utility tokens, and security tokens. What they mean by exchange tokens is a means of exchange, i.e. a Bitcoin or a Litecoin or an Ether. So these are the sort of classic payment tokens you might use to make a payment with. And broadly, the FCA does not regard these as regulated. In the United States, these are treated in the same way as commodities, so again, not generally regulated. In the UK, the FCA hasn't said exactly how they would treat them, but I think it's probably not a bad way to look at them as if they were sort of equivalent to money. And as many of you will be aware, foreign exchange transactions per se are not regulated. However, if you were to do a derivative based on a crypto asset in the same way as you were to do a currency derivative, that would be a regulated asset. Second category we've got, and I'm going to move straight to it, is security tokens. These are assets or crypto assets which broadly mirror existing financial services instruments like bonds or shares. Now, these are regulated, and I think the best way to look at those is to see the crypto asset as just another delivery mechanism. What the FCA is really interested in here is what the asset actually does. not whether or not it's a crypto asset or a paper asset or a straightforward share. If that asset gives you something which looks like a share in terms of the economic rights, then the FCA will treat that as a share. And it's the same with the bond, the crypto bond. Again, it would be treated in the same way as a bond would be treated. And the same thing goes for derivatives. So I'd say those fall under security tokens. Those are clearly regulated. And the question is whether by issuing crypto security tokens, you, as an issuer, you can reach a wider audience or raise money more efficiently than you can through existing means. And that remains to be seen from an economic perspective. Then the third, and from a legal perspective, most interesting category are utility tokens. And these are tokens which effectively what the FCA would describe as redeem for platform access. These tokens give you the right to do something. And these are the greyest area legally, because you have to analyze quite closely what those assets do. And so I'll give you an example. If I was to build a gym and I was going to raise £2 million of equity capital, those equities would be securities. If I was to say to you, if you invest in my gym, and obviously I can't have a gym at the moment during coronavirus, but when the coronavirus is over and I want to build my gym, I'm going to give you a year's free membership. That's a use token, not a payment token, and not a security. And the FCA has issued much more detailed guidance in terms of how these work. There's one other type of asset I want to mention specifically here, and that's stable coins. So stable coins are tokens which broadly reflect an underlying asset. And those are, again, a bit grey from a regulatory perspective. In their policy statement, the FCA have said that some stable coins are effectively securities, whilst others might not be. Now, the type of security they could be quite commonly is a unit in a collective investment scheme. And collective investment schemes are interesting because, unlike most securities, there's no limit in terms of what can go in a collective investment scheme. A collective investment scheme is effectively a group of people banding together and getting one person, the manager of that scheme, to manage the asset for them. Now, for example, you could have a collective investment scheme in horse races. Sorry, you could have a collective investment scheme in race horses, or in fine wine, or in art. And normally, of course, fine wine, art, race horses, these are not regulated assets as such. But within a collective investment scheme, they can be. And there is a danger that certain types of utility token or stable coin could be considered to be units within a collective investment scheme, and that has a regulatory consequence.
Nigel, I was going to ask you, do you think that the approach of the FCA is good for the UK's competitiveness when it comes to crypto assets and the regulation of them? How does the regulation here compare with other countries?
That's a good question. I actually think we are pretty competitive in terms of regulation. I also think we're pretty consistent with what other people are doing. I've attended conferences in Switzerland, and I've been in touch with people in the United States. The United States generally has a more restrictive attitude towards what could be a security. The usual rule in the US is, unless there's a good reason for it not to be a security, the SEC will consider it a security, whereas the FCA, being more of a principles-based regulator, you need to kind of fall within the category, otherwise you're outside of it. The Swiss regulators have come up with very similar, the FINMA, have come up with very similar type of categorizations. They've talked about payment tokens as opposed to exchange tokens, utility tokens, and asset tokens. An asset token being a bit broader than security token. But I would say the UK's perspective is quite competitive. The EU's also issued papers, and one of the areas I think could be interesting, obviously we're stuck in this coronavirus sort of stasis at the moment, but I think and we've also, when that's finished, we've got Brexit to deal with, but there is an opportunity coming out of Brexit for the UK to have its own distinctive crypto regulation, where we could make ourselves more attractive to issuers. Now, the countries doing that at the moment, particularly Gibraltar, Malta, and Switzerland, and they have sort of been the first to actually regulate certain types of utility token. and to be able to give you, the issuer, the assurance that your token is regulated, but it's regulated in a very light touch way, and that you're not going to face further investigation. And we don't have that yet in the UK. We have more certainty than we used to have. But I think it's one thing that's just telling is the way that the utility token market has rather sort of bombed in the last year or so. And one of the things, interesting things about crypto, and I think it is different, and it's a good question you've asked around the international perspective, because ultimately crypto assets are sold very internationally. It's a 24/7, 365 day a year, 7-continent market. If you go onto Coinbase and you're looking to sort of buy and sell your crypto assets, it's the boundaries, national boundaries don't really come into it. I mean, they come into it in terms of how those exchanges are regulated, but with the market is very international. If I sell my crypto, it could be bought by somebody in South Korea or in Australia or in China or whoever, as long as those countries don't ban the trading of crypto assets, which actually is the case in some countries. So what I think is interesting is the fact that the US has taken a much more restrictive approach, has actually killed off the utility token market in the UK, despite the fact that our regulator is not opposed to it. And that is because if you're issuing a crypto asset, you want to be able to issue it in the biggest markets. So I think we have some way to go. And I think the UK, as a substantial financial market, does have considerable opportunities, especially when you compare to, say, the likes of Gibraltar or Malta, which are very small markets, which have taken a very big share to date.
Thank you. I'd like to move on to Imogen and just ask about what I understand was an important legal statement on the legal status of crypto assets. And Imogen, if you could just explain what this legal statement is and how it actually defines crypto assets.
So the legal statement was issued in November last year, and it doesn't have any specific legal status. So it's not a piece of law, it's not legislation, it's just a group of people who are all in the legal sector who have come together to create a statement as a recommendation to the country. So it's made up of barristers, it's made up of Sir Geoffrey Voss. So the legal statement does some way to define crypto assets, but it quite rightly says that you cannot define crypto assets specifically, as they're quite a broad category. So instead, it decides to define it by their existence and the way that they exist within a system with rules, and they're made up of both public and private parts. So the public part being ownership, value, transaction history, and the private part being the private key, which allows the crypto asset to be transferred. The legal statement also defines them by reference to their novel characteristics, which it picks as intangibility, the cryptographic authentication, use of a distributed transaction ledger, decentralization, and the rule by consensus. So rather than giving a specific definition, it just picks out these characteristics that are novel.
Thank you. And what does the statement say about crypto assets as to whether or not they are property?
So in terms of property, it defines property in reference to a case from 1965, which says that property must be definable, identifiable by third parties, capable of assumption by third parties, and to have some degree of permanence or stability. It also references another definition, which says that property is to have certainty, exclusivity, control, and assignability. The statement then goes on to see if the particular characteristics of a crypto asset can fall within these broad characteristics of property. So just to briefly go through these, in regards to definability and certainty, the public parameter of a crypto asset is seen to be sufficient to define the asset and to identify it in relation to a person. Even though that person may be anonymous, they didn't see that to be problematic as long as it could be defined to a particular person. In regards control and exclusivity, they were quite satisfied that the authentication process, which gives a person who supposedly has ownership a private key, and that only that holder of the private key has control, was enough for exclusivity and control. Similarly, in regards ownership, having control of a private key would make you the lawful owner of a crypto asset, and that was seen to be sufficient for ownership. if somebody unlawfully got hold of a private key, that would be unlawful ownership in the same way that could happen with other property. They also discussed that a key could have multiple owners, it could have shared ownership, and it could be held on trust. In regards assignment and the transfer of ownership, they considered how and when ownership was transferred, and this would be when the owner transferred the key to another individual and the transferee then became the owner of the property. There was no way then that the original owner could transfer it onto someone else, which fulfills the normal rules of property. And in regards to permanence, they didn't see it as being any less permanent than any other conventional financial asset, which is also property. Therefore, they exist until they're cancelled or redeemed or repaid. So for all those reasons, it said that it seemed to fit within the definition of property, and none of the novel characteristics disqualified it for any reason.
Thank you. And why is it so important that that question is clarified as to whether or not crypto assets are property?
Well, property is recognised throughout the world rather than just specific rights that are given by a country in its own legislation. Property rights are recognised worldwide. And in particular, being considered property gives certain legal remedies, which may be recovery if it's lost or stolen, enforceability, injunctions, security, trusts, and it fits into rules with insolvency and bankruptcy.
Thank you. And I mean, you're right that the legal statement is not a statement of law as such, but I believe it's already been referred to in a case earlier this year.
Yes, in January this year, the judgment came out for AA versus Unknown, which is quite a strange case because there was only one party actually present in the court because the other parties were anonymous or yet to be defined. In this case, Mr. Justice Bryan referred specifically to the legal statement, and he noted that although it wasn't a statement of law, that the reasoning within the statement should be adopted by his court, and he advised that it should be adopted by the courts in general. He looked at the definition of property, as I discussed before, but as is already in the precedents in the court. And he said that on that basis, you probably wouldn't define a crypto asset as property. He then reconciled the definition with the discussions of the legal statement. He said, for all the reasons contained within the legal statement, you probably could consider it to be property. He also looked at other cases in other jurisdictions, including B2C2 versus Quinine, which is a case at the end of last year in Singapore, where they also considered crypto assets to be property. So for the purpose of that case, he said it would be property, which was important because the applicant was seeking a proprietary injunction and was successful in the proprietary injunction. So without the definition of property, they wouldn't have been able to get that remedy.
Thank you. I think I'd like to move on to Simon. Simon, you've been looking at smart contracts, and I think there's some issues in the legal statement about smart contracts as well. Perhaps you could explain what a smart contract is.
Yeah, thanks, Robin. So the legal statement also tried to consider the status of smart contracts in the context of sort of the English contract law in particular. And so a smart contract in its sort of purest form is a piece of executable code which will implement the terms of an agreement, and the idea behind them is that they are they take place almost automatically once certain conditions are fulfilled, and they require very little sort of human engagement in that process. So as I said, in the purest form, it would just be a piece of code hosted on a platform, usually a blockchain based platform. You can get sort of hybrid contracts which involve some sort of plain language sections as well, but in its purest form, it's just code. Sometimes a little bit difficult to can sort of get a concept of what that might be. A quite useful analogy is a drink spending machine. And so if you want to buy a can of your favorite fizzy beverage, you put your money into the vending machine, and more or less automatically, assuming that you've got the money right, it dispenses the drink to you, and it requires no sort of consideration of whether the terms have been achieved by any other means it ticks the box and you get your drink. So the important part of that is that the formation of the contract is almost instantaneous with performance. Performance and formation happen more or less simultaneously, which is both the strength and can be a bit of a weakness for smart contracts.
And so what approach did the legal task force take when analysing smart contracts in the sort of legal context?
They took a sort of fairly broad sort of principle-based approach, which was just to consider the constituent parts of a smart contract, the executable code and how that's implemented, and then sort of marry that up with the constituent parts of an English legal contract, which offer an acceptance, intention to create legal relations and consideration. And they basically came to the view that there was no reason in principle why a smart contract couldn't be defined as an English law contract.
But what sort of specific problems would the analysis of a smart contract present for the courts in England in terms of interpretation?
Yeah, so the broad approach is fine as a principle, but there are, as you say, potential problems with that. One is the language. The language of a smart contract is primarily computer code, which the court would require quite a lot of expert assistance to interpret. And actually, that code generally is written to perform the contract rather than necessarily to define the obligations of the parties, which is what courts are usually concerned with addressing. So it's likely that courts would have to look beyond the smart contract itself to identify what the intentions of the parties were when they were forming it. Although the contract, as we just described with our analogy of a drink vending machine, it's performed and formed at the same time almost. The courts will sort of need to look beyond the execution code to see what the intention, or rather may need to look beyond the execution code to determine what the parties actually intended. And another area that is common to lots of areas, lots of sort of blockchain and crypto assets and things, is that anonymity is quite often employed. So parties will be acting under pseudonyms or just simply won't disclose their identity, and there's a question over whether or not that's important when you're forming a contract. I think that the task force dealt with this in a quite straightforward basis. There's no reason under English law why parties need to know the identity of their counterparty. So they were quite sort of comfortable with that. A related but distinct point is the entity that is actually forming the contract. The example again we just used is that one of those entities when you buy your drink is a machine, and so query how can a machine have the capacity to have an intention to create a legal agreement? This is actually being considered in the case that Imogen just mentioned, the B2C2 case, and I think the court was happy that it was the coder who prepared the code to execute the contract it was necessary to have the intention to create the legal contract, and so it wasn't necessary for a machine to be considering that it was creating a contract. So I think that those things are sort of problematic, but not things that can't be overcome by the courts.
Thank you. One final question. So it's clear that these contracts, as you said, in terms of the drink vending machine, it's kind of automatic in nature. So that might suggest actually there wouldn't be that much to disagree with in terms of how they operate. So could you give us a flavour of what sort of potential disputes we might see in relation to the smart contract?
Yeah, I mean that's certainly the rationale that is put forward in some parts, is that these contracts are executed by machines who don't suffer the sort of human error that other situations you may find. But I think that's probably in real life not what's going to happen. Obviously, there are other things that can go wrong. One is the most obvious one is that there could simply be a coding error. Is that the parties have agreed the contract will take place and the product will be a certain thing, and yet an error in the coding has caused an outcome which one of the parties at least is not happy with, and so will want to seek redress. so that's an obvious area where it's simply a coding error, which one of the parties makes a mistake, and the other party will want to get redress for that. Another area is that, as I mentioned, but most smart contracts will be hosted on a platform, which will mean that the code itself has to interact with sort of third-party software of the platform, or perhaps of whatever it is that the contract is seeking to implement. And so it's possible that there will be outcomes which were not foreseeable by the parties when they were preparing the code. Perhaps they would interact and produce some sort of error, or it won't be implemented in the way they intended. And in those circumstances, you'd expect that it may be necessary at some point for courts to intervene to help the parties come to a resolution. And then just finally, there's the obvious examples of fraud and other illegality, which are common in all sectors. And one party may be in a stronger bargaining position. It's inevitable that there will be disputes in these areas, and so I think it certainly will be something that the courts will have to deal with. Just on a final point, how they deal with that, I think it will be fine where you have a smart contract which performs as perhaps a one-off transaction to make a purchase or to affect some other transaction. Courts will be able to consider those in the normal way and perhaps reverse them or transfer title to an asset which has been purchased. Those sort of scenarios I don't think will cause problems. Where you've got potentially more of an issue is where smart contracts are ongoing, and the execution of the contract is sort of a continual, perpetual cycle of transactions in a certain sphere. In those situations, you might find that you have to find a sort of novel way of dealing with that. If you've got a contract which is continually going wrong but can't necessarily easily be stopped, the courts might have to consider how to interact with that. Usually, if you had a contract in that situation, a court would simply apply rectification powers to kind of amend it in a way that the parties or it decides that the parties intended. With a smart contract, it might be that they have to novate the whole contract because you'd have to replace one smart contract with another. So I think courts will have to be looking at sort of novel ways to deal with these sorts of questions, which they simply haven't come across before.
Thank you very much. Well, that brings to an end our webinar, and I'd like to thank our participants. If you would like any more information from us with regard to crypto assets or smart contracts, there's further information on our website, or feel free to contact me, Simon, Imogen, or Nigel. And so all remains is for me to say thank you very much for joining us, and goodbye.